even if you're waiving, even if you're waiving the right to request repairs or appraisals or something, don't waive inspections. You don't have to do that. Most sellers should actually want you to do an inspection, frankly. But in any event, it is part of the crazy market. We're going to talk a little bit about that in my intro here. So for those of you who don't know me, my name is Patrick McQueen. I'm a real estate attorney here in Arizona. I've been doing this, gosh, almost 20 years now. Our firm handles all sorts of real estate matters, including commercial, residential, transactional, and real estate litigation. What I usually do when I provide some webinars, I just popped up my screen, by the way. What I usually do is I provide just kind of a little bit of an insight as to what I'm seeing crossing my desk. Okay, so before I dig into the homestead stuff, I do want to mention a couple of hot topics, just so you know kind of what's going on. Kind of keep yourselves out of trouble, keep your clients out of trouble, and have a great 2022. So first issue that we're seeing a lot of we're still seeing a lot of misrepresentation and non-disclosure cases. And I frankly think that has to do with the market as well. There's not a lot on the market. And so what we see are buyers who are just jumping in, taking whatever they can get, kind of allowing the sellers to dictate the terms. And then 3 or 4 months later, they realize, ooh, I should have done that inspection. Ooh, I shouldn't have waived all of these rights. And so I think a lot of the reason we're seeing a lot of misrepresentation and non-disclosure cases right now involve buyers who have a little bit of buyer's remorse. They're kind of disappointed in themselves, and then they turn to the seller or the seller's agent and say, you should have told me more. And ultimately it was on the buyer. The other reason I think that there is a little bit of an uptick was because we had a lot of rain in July and August. A lot for us. And so I think whenever we have rains that are a little bit heavier, we start seeing some issues getting pushed out or exacerbated: structural issues, pool issues, roofing issues. And so perhaps it's a combination of the rains that we had and a little bit of buyer's remorse. And so for whatever reason, those non-disclosure cases are a little bit on the rise. So just be mindful of that. Second sort of hot topic, and this has been a hot topic for us for about 6 months now, maybe a little bit longer, are specific performance lawsuits. Okay. And when I'm talking about a specific performance lawsuit, I'm talking about a buyer who has to sue a seller to actually perform under the contract, to actually perform under the Arizona Association of Realtors standard form contract. And the reason we're seeing this is we're seeing some sellers who say, oh, I didn't realize I picked the wrong buyer on this one. I'm going to find a different buyer and I'm going to try to get out of this contract. Or I think there's another $100,000 that I'm missing here. I think that the market's continuing to go up. I'm going to go and find a new buyer. I'm going to go and sell this property to somebody else without you even knowing. I'm going to go through a different title company. And I'm gonna be real sneaky about it. And that's a lot of what we've seen. And so if that's happening, if your seller is kind of hemming and hawing around about selling or not selling, well, guess what? You may be in a situation where the buyer needs to file a lawsuit for specific performance. And in connection with that lawsuit for specific performance, you need to record what's called a notice of lis pendens. Okay, a notice of lis pendens is basically Latin for notice of pending litigation. And all that really means, or what that really does, is it puts other buyers on notice that there's an existing contract. Okay, and so then other buyers are not going to want to buy that property because they're not going to get clean title. And so if you run into that situation, your clients need to file a notice of lis pendens, or they need to record a notice of lis pendens, and they need to file a lawsuit for specific performance. And in almost 100% of the time, you're going to win that lawsuit. It's a judge who will say, yes, I'm ordering specific performance. This seller must sell. But inevitably, this call happens probably 5 to 6 times a month right now. And I think that's pretty high. And I think also that has to do with the lack of inventory on the market. So sellers are kind of getting a little greedy and pushing that one. So specific performance claims for sure are on the rise. Misrepresentation claims. The other thing that we're seeing, and this is like kind of seasonal or tis the season for it, I guess. We're seeing a lot of commission and team agreement disputes. Okay, so people are fighting over commissions and people are fighting over team agreements. Like a team agreement in terms of, I get to keep these clients when we break up, you get to keep these commissions when we break up. Here's what happens when we break up. And people are kind of fighting. And so we usually do see a higher amount of those towards the end of the year and towards the beginning of the year. So everybody wants to end the relationship at the end of the year and start fresh at the beginning of the new year. And so we see a lot of those. So those are probably the top three things. If you need a team agreement, by the way, I give those out. You know, I want you to have a document that you can have and understand and comfortable with. So if you need that, let me know. Happy to get that to you after this mini webinar here. I can get you information on those other items as well if you need them. Now, the fourth sort of hot topic right now is this homestead thing. What the heck is going on with the new homestead laws? Okay, we had some legislation back in May, or that was signed into law back in May. It goes into effect. It went into effect, but 11 days ago, January 1st, 2022. Okay, this is a huge change for the way in which we've always treated homestead laws and homestead properties here in Arizona. Okay, for the last 100 years, okay, a recorded money judgment against somebody's homestead property didn't really mean much here in Arizona. Okay, Arizona Homestead Law allowed a homeowner with a recorded money judgment against them to sell their homestead property free and clear of that judgment. Okay, and let me make sure I kind of clarify that. So I go and get, as an attorney, I go and get a judgment against somebody for a misrepresentation claim. We record that judgment. All right, that judgment doesn't mean much if the person who I have the judgment against, the judgment debtor, okay, it doesn't really mean much if they're selling the primary residence. If they're selling their homestead property, I don't get any of that money. Okay. Now, if it was a secondary property, we would, because that's not homestead protected. But a judgment is one thing. A lien associated with the judgment is another. So the judgment is there, it's recorded, but it passes without a lien. There's no lien to interrupt the sale of somebody's homestead property. Okay. And so if there's a judgment, a title companies, they really don't do anything with that. There's no payoff. The judgment stays there. What gets recorded is a lien release. The lien associated with that judgment is released. And so the judgment stays on somebody's property, or it stays recorded. It's not satisfied. The person sells their house free and clear of the lien that's associated with the judgment. Okay. That's what a true homestead exemption does. It means that if somebody has a judgment against you, there's no lien associated with that judgment, meaning I can sell that piece of property. The lien is gone. It's of no effect as to that piece of property. Okay. And that's what we think of when we think of homestead laws. That's what we think of when we think of the states with the biggest homestead exemptions, the biggest homestead laws, like Texas and Florida. Now, Arizona had a good homestead exemption. Now, I don't even know if we can call it a homestead exception or exemption. Okay. And we'll talk about why. Okay. So now those judgments that are out there, those are going to become a lien automatically. Remember, they weren't a lien. Now they are a lien automatically. So I now have rights of a lien holder. Okay. So see, on the screen that I posted here, this is sort of the history, right? For all of these years, no lien attached with a judgment against somebody's homestead property. So you can sell your homestead property, you can cash in on that. Okay. So before I had no rights, now I'm a lien holder, and I'm a lien holder against your primary residence. Okay. Now, the good news is that the amount of protection, all right, the amount of protection has gone from $150,000. So I automatically got the first $150,000 on a sale from the homestead exemption. Well, that amount has now gone to $250,000 in some instances. Okay. So there's been an increase in the amount of protection you have, the amount of equity you can protect through using the homestead exemption. but largely you'll see how it changes. Now creditors are going to get paid. Now creditors are allowed to be lien holders, which is much, much different than it really ever has been. Okay. So under the statute, I'm just going to kind of give this to you very generally. And then we're going to go into 3 rules those are the rules that are going to be the most important. But under the statute, if I, as a homeowner with a judgment lien against me, I'm trying to sell my primary residence, okay, my homestead property. If I'm going to receive $200,000 or more, a notice of pending sale is now going to get sent to my creditors. Okay. My creditors then have the opportunity to object to the sale or to object to whatever in that settlement statement. Okay. Let me repeat that again. Okay. If I'm expected to receive $200,000 or more from the sale of my home, and there's a judgment out there against me, my judgment creditor gets notice of that. They get an opportunity to object to the sale of my house, to the commissions that are listed on the settlement statement, to pretty much anything else. Okay. That's the biggest change. And so what we're keying in on this whole time is going to be the proceeds to the seller. All right. Okay. So if my creditor goes out and objects to my sale, if my creditor objects to the sale after they get notice, guess what? I now have to file a lawsuit to figure out what their issue is so that they'll agree to allow my sale to happen. Okay. So anytime you have a sale where your seller is going to get $200,000 or more, notice goes out. If there's an objection, that creditor has an opportunity to object, and now your transaction is going to be delayed until the lawsuit can be figured out. Okay. So this also applies to existing judgments. It's not judgments that I get against somebody or an attorney gets against somebody in 2022 going forward. It's all existing valid judgments. Judgments are valid for 10 years at a time. Okay. So we can look back 10 years. So there's going to be a bunch of judgments from 2012, the short sale days, that are going to come back and bite people because they thought they went away, because they didn't, that lien never attached. Well, now those mean something. All judgments now mean something. All right. So again, the key here is going to be looking at the proceeds to the seller in all of this. Now, that's on a sale. Okay. That's on a sale. And I'm giving you this general overview of how this is going to change. We're going to get into some specifics of it. That's on a sale. Leah asks, who is responsible for notifying the lien holders? 100% on the title company. Okay. But what I'm going to suggest to you in a little bit is that you get ahead of this, Leah. You as real estate agents, start taking a look at Schedule B documents, start getting title reports a little bit early on, because what if you have somebody who wants to close within 10 days and there's a judgment out there? It's not going to happen. It can't happen because this 20-day period has to exhaust itself. So the responsible party is the title company. Under the statute, the title company has to notify the lien holders. Okay. So what I just gave you was a general overview on sales. Now, refi transactions are a bit different as well. Okay. So on a refi, depends on if it's a cash out refi or a non-cash out refi. In a cash out refi, my primary lender is going to get paid off. Then before I get paid anything, any lien holder out there gets paid first. Okay. That's not the law as it was as of December 31st. That's the new law going forward though. Okay. And so no matter what, if I'm doing a cash out refi, any of those judgment holders are going to get their money before I get any of my cash out. Okay. On a non-cash out refi, the statute basically says, look, the title company can issue a subordination so that the deed of trust still remains superior to any of those judgment holders. Okay. So there's really no change. There's not a huge deal on the non-cash out refis, but on the cash out refis, when you're taking cash out, there's going to be a big difference. Now, the question becomes, well, what is this really going to do? What's going to happen? Well, I think there's going to be a lot of delayed closings. I think there's going to be a lot of litigation. I think there's going to be bankruptcies for people who are discharging these judgments that really didn't mean much for such a long time. I think it's going to create acrimony between selling agents and sellers, because sellers are going to say, well, I thought I was going to get a certain amount. You told me I was going to get X, Y, and Z. And then ultimately, here comes the lien holder who has a say in this. And I think it could create a little bit of a strife between agents and their clients. So how did we get here? What happened? Why did this change? What do we, because again, what we had was a very easy to understand statute. You got $150,000 of equity. There's no lien associated with this. I can sell my house. Not a big deal. Renee, what if the seller filed for bankruptcy when they did a short sale of their home? So the bankruptcy, a prior bankruptcy, you're going to be fine. If that's going to discharge all of those other items. It's just for those, there's a lot of judgments that are out there right now from the short sale days that, hey, somebody got a judgment against me and they never really sought to collect on it. Well, now they're going to be able to collect on it when you sell your house. And so that's going to be out there. That's going to be interesting. But if you already had a prior bankruptcy that discharged those judgments, then they don't mean anything. Then they're fine. You're fine there. It's not going to re-engage judgments that were already taken care of. It'll re-engage judgments that were never paid off or satisfied. And that's the scary thing. A lot of people don't even know that they have judgments from 8 or 9 years ago, or they've just kind of put it out of their memory. Well, these are going to come back and people are going to have to lose a little bit of money on the sale of their homes. So Alicia has a question. Are there asset protection owners can do to protect their assets, like purchasing their homes through an LLC to avoid personal judgments from taking their home? There are, yeah. And there are ways to avoid some of this stuff as well. If you're putting it in an LLC, if you're putting your primary residence in an LLC, then you're not going to qualify for any of the protections afforded by the homestead exemption. But I don't even think this is a homestead exemption anymore. So there are things you can do for sure. And there are ways, people do family limited partnerships, people do LLCs. There's all sorts of ways to kind of look a little bit cleaner on paper and look a little less likely to go after. So Marianne, I think, is there a statute of limitations on these judgments? So there's a 10-year statute of limitations on a judgment in Arizona, but that judgment can be renewed prior to the expiration of the 10th year. Okay, so in theory, you could renew a judgment for somebody's lifetime if you really wanted to. So they go 10 years at a time, and then they get but they have to be renewed each 10 years. So that's a 10-year statute of limitations in my view. They don't really call it a 10-year statute of limitations, but that's essentially what it is. So that's a really good question. So yeah, that's why this statute is problematic, because it re-triggers old judgments that never really meant anything. So how did we get here, guys? Well, we had this case. It's called the Castleton case. Came out in 2016 or 2017, and basically a guy sold his house and he had a $5.2 million judgment against him. He short sold his house, and the bank that he owed the money to never got a dime. And so they got mad. And so they're now trying to get even through all of this legislation. And so what we have in Arizona, a lot of people, a lot of debt buyers, a lot of banks, a lot of credit card companies who are able to get judgments or who trade these judgments, they're saying, well, we're not getting paid. Arizona isn't the state to come to if we want to get paid, and we want to get paid here. And by the way, look at what happened in this Castleton case. All these judgment creditors, are getting nailed because there's this great homestead exemption in Arizona that you have. Well, we don't want that to happen anymore. And so all of this was this big overreaction, in my view, to that particular case that came out. And it's really going to do some damage here to a lot of real estate transactions, which is unfortunate. So remember what I said. There's 3 rules that I want you to remember from this. Okay. And these are the 3 rules right here. And by the way, if you want these slides, just shoot me an email. After this, I'll get you my contact information. This stuff takes a while. This to study, to understand. The statute itself is 8 pages, and it's lawyer and legislature talk. So it's tough to get through. But these really are the 3 rules that I've sort of boiled this down to. And again, what we're looking at are proceeds. Okay. So in rule number one, if the seller has a judgment against them and the proceeds from the sale of the homestead property, okay, the sale of the home, do not exceed $200,000. Okay. If it's $200,000 or less, there's nothing that needs to happen. The title company can record a release of the lien associated with that judgment. They're not satisfying the judgment. The judgment doesn't go away. The lien associated with it does, though. Okay. So if $200,000 or less, seller gets everything. Okay. So you really want to find those sweet spots for your sellers who are getting $200,000 or less in proceeds. So if the seller's going to get 200,000, no big deal. Same as old. Okay. If the seller has a judgment, but is going to receive between $200,000 and $250,000 in proceeds, well, again, guess what? This is when the notice must be provided to the judgment lien holder. And the notice is going to be a copy of the settlement statement, a notice that there's a sale going through, a notice that the title company has calculated these amounts. And if the lien holder files an objection within 20 days and says, I don't like what these amounts are way off, I'm entitled to more, you can't do this, etc. Well, if that happens within the 20-day period, the sale stops. Done. Title company won't move forward. Okay. And at that point, your seller's going to have to make the determination whether they want to fight this judgment lien holder, this creditor who's saying that more is owed, and they want to go to litigation to fight over it, to figure out what that amount really should be, or what's really going on. Or they end up saying, here, I'll pay you such and such amount, be done. And these judgment lien holders, these credit card companies, all sorts of folks, these banks are going to get paid. And so that's the seller's dilemma right there. Okay. Now, third rule, if the seller is to receive over $250,000 in proceeds, then the judgment lien must be paid and satisfied. So the judgment has to be, if I'm a seller and I'm getting $250,000 or more, then automatically the judgment now has to get paid and satisfied. Okay. So in addition to the notice and all of that other stuff, but if I'm going to get 250, judgment holder gets paid no matter what. Okay. In full. So let's go over a couple of examples, because I think these might be helpful. And again, you're more than welcome to have these slides and certainly study them. Happy to get you whatever other information you want, get you a copy of the statute if you want it, if you want to put yourself to sleep. Okay, example one, sales price is $400,000. There's a deed of trust for $200,000, commissions and closing fees of $30,000. So we got $170,000 left over. In this case, this goes at rule number one, title company releases the property from the judgment lien. The seller gets their $170,000. No notice to the judgment creditor has to be provided. Okay. Example two, sales price is $400,000. Existing deed of trust is $150,000. Closing fees are $30,000. So our judgment debtor, our seller who has a judgment against them, is going to get $220,000. So this puts us in the $200,000 to $250,000 range. In this particular instance, notice has to be given to the judgment lien holder. The judgment lien holder has 20 days to object. Okay. This to me is a standard transaction. The $30,000, $10,000 judgment, or whatever it is, $220,000 of proceeds. It's pretty standard, right now with all the equity that people have. Okay. So in this particular instance, if there's a judgment lien holder, and by the way, it doesn't even matter the amount of the judgment. If it's $1,000 judgment, it's a $500 judgment. If it's a $50,000 judgment, notice has to be provided. Okay. So in this particular instance, our seller is going to get $220,000. Notice has to be provided. Now, if the judgment holder objects, if the lien holder objects, we got a problem. Our seller has to file a lawsuit to clear the lien. If there is no objection, then the title company can release the lien. Okay. Looks like there was a question that came in. Okay. Yeah, you're right. Okay, perfect. So that's our sort of middle, rule number two. Okay. Let's see. Now, how about this one? Sales price is $400,000, or deed of trust is $100,000. Commissions and closing costs are $30,000, and there's a judgment for $10,000. Okay, so in this particular instance, the proceeds to the judgment debtor exceed $250,000. Remember what happens in that situation. The judgment, the creditor, the lien holder, gets paid in full. Okay, so in this particular instance, yes, notice has to be provided, but guess what? The judgment lien has to be paid in escrow for that release of the lien. Okay, so in this particular instance, the judgment lien gets paid off for $10,000. Our seller gets what they get. And so again, remember the rule: when the judgment debtor, the seller, is going to get $250,000 or more, and there's a judgment out there, the judgment has to be paid in full. The judgment has to be satisfied in that situation. Okay. Now this one's a tricky one. Okay. So in this particular instance, sales price is $400,000 again. Deed of trust is $100,000. The commissions and closing costs are $30,000, and there's a judgment for $30,000 as well. Okay. So on the settlement statement, our seller is set to get $270,000. But remember the rule. The third rule says if there's $250,000 of proceeds that are supposed to go to the seller, well, guess what? The judgment has to be paid. Okay, and so in this instance, what happens is well, I guess the question is, should the title company release the $250,000 to the judgment debtor, the seller, and release the additional $20,000 to the judgment lien holder, even though the judgment lien is $30,000? The answer here is no. Okay, so everybody thinks, well, I have $250,000 of protection, therefore the judgment lien holder should only get $20,000. No, under this rule, you're going to actually get less. Okay, this seller is actually going to get less than the $250,000 that they thought they had in protection, because they were scheduled to get more than $250,000 in proceeds, but the size of their judgment lien is big enough to reduce that. Okay, so in this particular instance, I don't even get my full $250,000. I get less. Okay, because the judgment lien has to be paid. That's the rule. Okay, so this is going to trip up a lot of people. Alicia, I think, did I answer that? Did I? Hopefully I answered.
I'm gonna, so can you give the final, so you're giving examples, but what does the seller actually walk away with? In this case, would it be 240,000?
240, you got it.
Okay.
Exactly.
Okay.
Yep, 240. Yeah, sorry. I may have skipped over that last step of telling you what they actually get. But yeah,
Yep.
and in the prior instance, they get 260. Yep. Great question. So this is the scenario. This is the ugly scenario right here. If I'm expected to get $250,000, yet my judgment lien is so big, I don't get anywhere near the $250,000. People are going to be very, very surprised, because they are all under the impression that this new statute says I get $250,000 of protection. You don't. You don't even, you could potentially get a lot less. So in this particular instance, $240,000. Great question. Okay. So Leah says, looks like a good way to ask for more commission is to get the net under $250,000. Yeah, well, I'm going to tell you something in a second here, Leah. You don't want to be messing with commissions or getting queued on some of these settlement statements, because here's an example. So this is a cash out refi example, or non-cash out refi example. Okay, so in this particular instance, very, very simple. The title company has authority under the statute. They don't even have to ask for permission to issue a subordination. So basically, the new deed of trust for the refi transaction remains superior in time to the judgment lien. Okay, great, no big deal. It's kind of like what we already have. Okay, so in this particular instance, the home value is $400,000. Deed of trust is $100,000. And the borrower is saying they don't want to do a cash out refi. Okay, they're just it's rate and term only. But surprisingly, on the settlement statement, the mortgage broker is getting a $50,000 fee for the refinance. Okay, can't happen either. All right, And the reason that can't happen is because under the statute, an unreasonable fee is being charged. So one of the things that allows creditors and others to object to a sale are unreasonable fees. And so what they're trying to do is protect against a situation where you're saying, well, I'm not doing a cash out refi, but I'm going to pay my buddy, who's the mortgage broker, who's the real estate agent, an overinflated commission, an overinflated fee, so that they can sneak out some of my money and pay me back, or so that they can keep it, so that the creditor can't keep it. And so in the statute, Leah, this is exactly what we're talking about. You got to be careful from having unreasonable fees, because this transaction may get slowed down as well now because of this fee that shows up. Okay, so it's a really, really bizarre statute, guys, that just really, I was kind of kidding. Yeah, I know you were, Leah. But now under the statute, we can't be kidding, which is pretty wild, pretty wild stuff here. So this is going to trip up a lot of people, I think. A lot of folks are going to be unhappy when they get notice of these judgments. Now, as I mentioned, or Leah was asking a question about the notice that's required. So the notice has to be provided by certified mail or registered mail, and it's deemed delivered once it's signed for, or 5 days after it's delivered. Okay, and all sorts of notice is going to be in there. The title companies have to do this. I don't know if the title companies have a new rate chart to, to determine how much they're going to charge to send this kind of notice. But all sorts of stuff is going to be provided in that notice. And guess what? The more information that gets provided, the more they're going to object to. And so, that's part of the problem. So Alicia has another question. What if the lien judgment is greater than the proceeds? That's, I don't know the answer to that. The statute doesn't really address that. I would say that probably the lien is going to get paid down so that the sale can happen. But that's a fair question. Nobody knows what's going to happen in that particular situation, because I've run into people who ask that very same question. They show me their judgment and I go, we'll have to see what happens. I don't think in that instance the seller's going to get anything. And so you've basically completely cut out the homestead. There's no homestead in that situation. There's no homestead law that would help anybody in that situation. So that's a great question. And the law and the statute just has a blank when that particular question comes up. So you've identified that one perfectly. What about selling the home for less than market value in order to stay below that $200,000 margin? Alex, great question. That's what I've heard a lot of people are saying. Always keep that amount at 200. Always keep your equity around $200,000. I mean, that's what people are coming up with. Lisa, because title is a neutral third party, do they get to decide, or who does it get escalated to? Yeah, another great question. There's so many questions that are unanswered by this statute. So the title company is probably going to do as much punting on this, at least initially, as possible, because they don't even know. I've talked to title companies who are like, we're hoping this thing goes away. We're hoping there's new talks to get rid of this. We don't know how to apply it. We don't, there's all sorts of problems. I think title is not going to make any decisions on these. I think title is going to say, we can't move forward because an objection was put in. We're not going to move forward. Either the parties themselves have to address it, or you have to file a lawsuit. And I think a lot of this is going to go to lawsuits. And so a lot of these, who lobbied this new legislation bill? So it was all of these creditors. They want to get paid, and that's who did it. And it's a fellow real estate attorney who does a lot of work for the creditors, banks, who actually drafted this statute. And I've heard that the Arizona Association of Realtors is pushing hard against this because it's going to cause so much confusion. There's going to be specific performance lawsuits being filed like no other, because if I'm a seller and I'm stuck going through this process, but I have a buyer and I'm on the hook to sell this buyer within 10 days or 14 days or whatever, and I can't because this creditor is taking forever, I'm going to get hit with a specific performance lawsuit. I mean, it's going to create a big mess. So so there's a lot of folks that legislated for, or that lobbied for this bill. But I know that the AAR is starting to push back. I'll tell you guys one other thing, that the statute doesn't really address this. Okay. But what I think is going to happen, and again, this is just me thinking through how this stuff may be working now. We may have a priority issue, a priority. And when we talk about priority, what we're talking about are first in time, first in right. Okay. And, this takes some of you guys back to, your first couple of classes in the real estate school. But when we talk about priority, what we're talking about is who has the right to enforce, and who has greater rights in a piece of property or greater rights in money than the other person. Okay. And so this becomes a big time title issue when we're talking about priority. If I've given a deed to a piece of property and I record my deed first and you get the same deed, but you record it 2 days later, well, I win because I recorded first. Okay. That's what really priority refers to. And I think that this statute is going to have a big effect on priority of deeds of trust and deeds and other recorded documents. So as far as I can tell, a deed of trust that's recorded prior to December 31st, 2021 is still going to hold priority over a previously recorded judgment. That's just how the statute works or worked. Now, a deed, I give you a deed, a regular old deed recorded on or before December 31st from a judgment debtor to a buyer, from a seller to a buyer, is probably safe from a previously recorded judgment. And that's what we want. We want our buyers to be able to get clean title from old judgments. Okay. But I think after January 1st, I think now a deed of trust or a deed recorded now is going to be junior to a previously recorded judgment. And in the history of Arizona for the last 100 years, that's never been the case. And so now what that really means is all of these recorded money judgments are going to have to get satisfied. Otherwise, we have some significant priority issues and timing issues, and who has better rights and what's really happening here. So I think that a lot of these judgments are going to get paid off because of this priority issue. And I think creditors are going to get paid pretty handsomely for all of this as well. So big time issue. Okay, so I just came up with a couple of little bullet points for agents. Frankly, because of the timing issues here, I really think you need to have conversations with your clients ahead of time. If there's any concern that there's a judgment out there, then you really need to have that conversation, because that's going to affect the sale date. I mean, you're not going to be able to close in 20 days. You're not going to be able to close in 30 days if there's a judgment out there. And so if you can get title reports and title documents, get with your favorite title company a little bit earlier on in the process, get those Schedule B documents, see what those judgments say, and try to figure out these numbers to see if they're going to be between be over $200,000. That getting ahead of this is really what you need to do. Have the awkward conversation with your clients about judgments. The SPUDS does require them to check off whether they're aware of any judgments or not, but a lot of people just aren't aware of it. And so, you may have to have that conversation that says, hey, look, is there a judgment out here? Because this could really bite us, and this could really slow down the process. And so to the extent these timeframes, to the extent you're getting these documents ahead of time, you're going to be much better off if there's a surprise that comes. So that's all I have. I'm going to open it up to some questions here. Looks like a couple just came in. This could really change the market if all the old short sale judgments prevent sellers from putting their current homes that have much appreciation on the market. Those may be coming up to 10 years old. That's exactly right, Leah. I think now is when those are going to start to rear their heads. And again, remember, these are 10-year judgments, but you can renew them, and so they can last until they're paid off. And so I think that's part of the concern that the AAR has. If you're going to go and change this rule, well, make it for all new judgments. Make those continue to apply the old judgments in the old way. And if you want to move forward, then don't make all of these judgments get resurrected, because that's exactly what we're doing. We're resurrecting old judgments that meant nothing for 10 years. Pretty wild. Hypothetically, if a title company didn't do their job right and a judgment was overlooked and all the funds have been dispersed upon closing and the creditor finds out, do they go after the title company or the seller? I think they're going after both. Under the statute, it's the title company's obligation to provide notice, but if they want to get paid, they still have that judgment against the seller. So I think they're going after both. So I think there's going to be, I think title companies are going to miss some of these for sure. I mean, that's why we have title insurance. And so I think creditors going after both of them. Great question there. After the 10 years, how many creditors actually reinstate the judgment lien again? That's a really good question, Michelle. I don't know the answer. I would say most do. I would say most do. And I would say most will try to reinstate a lien again. Yeah. I thought most businesses wrote off judgments as loss. Yeah, you know, there's an interesting argument out there. So there's a difference between a write-off and a release of the judgment. Okay. So remember, a write-off is something they show on their books. A write-off is something they just cross out. We're not going to collect this. But a judgment is actually the recording of that information. So they go and they write that off. Maybe there's a tax benefit, whatever it is. But guess what? There's case law from Arizona, here in Arizona, that basically says just because you wrote off a debt doesn't mean that the judgment went away. There's still a judgment. And so they're going to get lucky. A lot of these folks are going to get real lucky. A lot of these businesses are going to get real lucky. They wrote off the debt 8-10 years ago. We're not going to collect this. We can't collect this. We're never going to see a dime of this. Well, now they're going to, because they went through the process of recording that judgment 8-10 years ago. And so, yeah, they're going to come up. Let's see if there's some other questions.
I got a question that is a little too long to type.
Sure.
So you say know and understand all time frames. If somebody has a lien judgment from an HOA, from county taxes, and a creditor, are there different time frames for each?
No, it's 20 days. It's
20 days. Okay.
20 days.
So it doesn't matter what the time. Okay. Okay.
Nope, 20 days. And so, yeah, so when I say know and understand the timeframes, really what I'm talking about is, you know, if there is a judgment out there, what is that going to do to our closing time frame? What is, you know, if we open escrow today, we want to close in 30 days. Is that realistic if the seller has any judgments out there against them? We want to make sure that time frame makes sense. The other part that, you know, that I think about every once in a while is, well, what happens if we're actually proceeding to close through escrow, and 10 days before close of escrow, a judgment gets recorded or a judgment gets found? Well, then the 20 days begins. We were set to close in 5 or 6 or 10, and now we're not going to be able to close because now I have to honor this complete 20-day period. I think those are going to come out of the woodwork as well. And those are going to really surprise a lot of people as well. So great question there.
So if a seller makes a settlement with a judgment, say from back in 2000, you said you can go back to 2012. What if they made a settlement in 2016? That judgment can't come back at them because they made a settlement.
If the settlement was documented properly, and
Okay.
what I mean by that is if the judgment went away, if there's a release of the judgment, a satisfaction of the judgment, it's gone. There's nothing there's no concern there.
Thank you.
You got it. Let's see. So we talked about the write-offs and how write-offs, that's a business function. And we have case law that basically says just because you write it off doesn't mean you can't go after a judgment later. Can creditors sell these judgments? Yes, they do. They trade them all the time. Sometimes they package them up, sell a bunch of them at a time. So Stephanie, that's a good question too, because let's say that a creditor has sold a judgment or traded a judgment to another creditor, a debt buying company, but we don't know the new contact information for them, and it may delay the process even more because we don't even know who the proper party is to provide notice to.
Does that, does that start the 10-year all over again? Because it's a new creditor, or, I mean,
No.
if they were, no, okay.
No, it all goes back to the date of the original judgment. Yep. Good question there. It does not do anything to re-trigger deadlines. If someone files for bankruptcy, should those judgments be cleared from being against an individual? Yeah, once the bankruptcy is in place, then those judgments, those go away. And as long as the bankruptcy is discharged, then you're fine. Let's see. We all have access to Maricopa County Recorder's office, and maybe part of our due diligence, we should be looking up our sellers to see if any judgments are showing against them. Yeah, isn't that a pain in the butt? But yeah, you may need to do that just to do a little bit of background and do some due diligence. Certainly, the title companies are going to provide. I think a lot of title companies are coming out with new products that are going to allow you to get in front of this a little bit quicker. Like these pre-listing kits. It looks like somebody wrote something. The pre-listing kit from titles should help. Yeah, I think those will help. Let's see. So seller has proceeds over 250,000. If they have judgments all over 100,000, all judgments have to be paid, not just down to 200 or so. Yeah, I think that's right. So that's kind of where the statute goes blank. And I think Alicia asked a question about that earlier. I think there's a real distinct possibility that if there are enough judgments out there and you were expected to receive proceeds of 250,000 or more, those judgments are getting paid off and you're not getting any of it. Another question, does a 1031 exchange make a difference if the equity is placed into the next property? Well, so the 1031 is intended to, you shouldn't be 1031ing. So I don't think this statute is going to apply to 1031 properties because this addresses your homestead property, and most people, you can't do a 1031 of a homestead property because that's your primary residence. It's not used for business or rental or investment. So in all likelihood, the 1031 is not going to do anything to help. How likely is it that AAR can convince lawmakers to change this? I don't know. I know that there's a lot of people who are very unhappy about this. Title companies, the AAR, real estate agents. I've been trying to get the word out for a couple of months now that says, you guys need to wake up. There's a problem here. And I think people are finally starting to realize, yeah, there's a potential problem here once they work through the statute. I mean, this is solely here to benefit the banks. Frankly, it's going to benefit lawyers. I mean, it's going to create more work for me, but it's not fun work. So there's a couple of parties that benefit out of this, but it's not homeowners. This was not an improvement, I don't think. And it's certainly not going to help real estate agents. It seems like a money grab at the equity that we now have in our properties here in Arizona.
I just want to ask a couple follow-up questions here. So this is only primary residence. So if you have a property that you're renting out, essentially none of this applies.
Correct. You don't get any protection there. They can go after 100% of the proceeds for a non-primary residence. Correct. For an investment property, a rental. Yep.
Okay, so that's automatic. It can be whatever judgment. Okay.
Yep.
I gotcha.
Exactly. Yep. Exactly. So when we're talking about homestead property, we're talking about the property you identify as your home. And I know that's a vague description, but that's really what the cases and statutes say. So what we look for when we're determining whether, a house up in Sholo versus your house in Phoenix, which one do you live there, more days out of the year? Where do you send your mail to? What's on your driver's license? That's usually what the homestead is going to apply to, whichever one you have more of these sort of factors that go to. So if it's an investment property, it doesn't qualify at all. If it's a rental, it doesn't qualify at all. So it only applies to your primary residence. And so this is some protection, I guess, from creditors if your equity, if your proceeds are low enough. Then there's some protection here, but otherwise there's no protection on a an investment property. So let's see, looks like a couple other questions. Seller had a judgment that is accruing interest daily. Prior to seller dying, he did a warranty deed passing the home to the daughter. She's now thinking of selling. That judgment lien will be there and will have to be paid. I just lost that question. That judgment lien will still be there and will have to be paid based on the proceeds amount, correct? It didn't go away with the warranty deed. That's correct. That's correct. Did not go away. Time for some commercials on TV to get the word out. Are you a real estate attorney? I am a real estate attorney, but you won't see me on a commercial. Sorry. That's funny. I believe you addressed this, but if you have your primary residence in an LLC, you have no protection. Correct. Yeah. Doesn't help. And it may hurt because if you're putting it in an LLC, you're saying, well, this is a business and therefore it's not going to qualify for any of the protections. Will this result in easier terms from banks and lower interest rate for consumers as their risk is now lower? That's a great question. I don't think so. I don't think so. Yeah. So Deanne asks, property in a living trust. That's not going to give you any greater protection. I still think that's a good idea for a number of other reasons, but it's not going to give you it's not going to give you any additional protection. It's not going to lose you protection. You can still have a homestead property that's owned by a living trust, a revocable living trust, but you're not going to get out from under this statute by virtue of that. I don't know how. I haven't come up with my list of tricks yet to figure out the workarounds around the statute. I mean, there are workarounds for the other statute. There's workarounds for creditor law, that sort of stuff to protect your equity. But I haven't figured out the workarounds yet because they even included something in the statute that says, hey, all the fees have to be reasonable. Hey, those would be the workarounds that I probably would have come up with, that just said, well, I'm just going to pay my uncle here to do my loan, and then he's going to pay me back. But I haven't figured out the workarounds on this one yet.
So essentially, if an elderly person owns a home and then they end up with large amount of medical bills, the medical companies take all the equity and it's done.
Very real.
If they go to sell, if they have to go to assisted living or something, right?
Yeah. Yep. That's a very, very real possibility.
So essentially, if you get old and sick, you want to make sure you don't have any assets.
Yeah, and there are attorneys out there who can kind of help with that. Sometimes they can kind of like you set up family limited partnerships so that you don't own any of the assets anymore. There's certain types of irrevocable trust that you want to set up, those types of things that basically get the money out of your hands so it doesn't look like you have anything.
Yeah.
Great questions, guys. Yeah, I know this is an interesting one. It's a bit frustrating. Seems like it's a bit of overkill. And that's kind of what I think too. Here's my contact information, by the way, guys. If you need the slides, if you want to study those, if you need a copy of the statute, if you want the case that started it all, any of that stuff, it's on the screen here. You're more than welcome to have that. And so I don't know if anybody else has any questions, but We can probably sign off here if you don't. Quick claim to protect a sale, not usually gonna do much. I think the creditor who has a judgment, yeah, I don't, I usually tell people to avoid various transfers. I think it's just going to get more people in trouble because we have fraudulent transfer statutes that can get you nailed doing stuff like that. All right, guys. Well, we'll sign off for now. I hope everybody has a great 2022. Is Lisa
Thank you,
there?
Patrick.
Yep. You got it. Thanks, guys.
Bye-bye.